Welcome to the COVID-19 Public Health Orders and Police Powers webinar. So my name's Kirsty Harrison. I'm a lawyer here at Legal Aid and I'm currently the manager of the WDO service in the Civil Law Division here. Before we start the session today, I would like to acknowledge and pay my respects to the traditional owners and custodians on whose land we are broadcasting from today. I'm on Darkinjung country and I would like to pay my respects to this land and its people and to acknowledge elders past, present and emerging. I'd also like to acknowledge all Aboriginal people and Torres Strait Islander people that are joining our webinar today, and also if I could also reach out to my Aboriginal colleagues at Legal Aid and acknowledge the incredible work they do, and also all the participants today who work across the community, health, legal, youth and justice sectors and who are committed to improving outcomes for Aboriginal people. Sovereignty has never been ceded, it always was and always will be Aboriginal land. So just having a look at what we're going to cover today. Again, it will be about 90 minutes. We have a really jam-packed session that we've broken up into 3 different parts. The first part will be an overview of the public health orders. The second, I'll hand over to the human rights group, who'll take us through police powers under the public health orders. And the last part of the session today will be Law Access and the WDO team taking us through options for dealing with public health orders, and we'll also look at some case studies. When you registered for today's session, we asked what you would like to see covered. So we've tried to include as many of your questions into the presentation. If you do ask questions throughout the session, we may not get time to get through all of them, but we will respond to you by email. So let's get started. So I would like to introduce Cherie. So Cherie, are you there?
Yes,
Good
hi,
morning.
Kirsty. Hi,
Good morning. So Cherie is the manager of our in-house counsel unit here at Legal Aid. I was only saying to one of my colleagues yesterday, I couldn't think of a more complex in-house role than being the in-house counsel in an organisation of lawyers. So I can't even imagine some of the work that crosses your desk. But thank you so much for being here today. So I thought, Cherie, we could maybe just start today our session with a poll and introduce the public health orders. So might ask Kerry to launch our second poll. So that should be coming up on our screen now. So the question is, what do the Deputy Prime Minister, a former Prime Minister and a pair of nude sunbathers in the Royal National Park have in common? Okay, so we've got 3 options. So option 1, possibly too much to include in a sentence. Option 2 is that they were in fact the nude sunbathers. And option 3 is that they were all fined for breaching public health orders. Any ideas, Cherie?
Well, I kind of know the answer, but do I spoil the poll?
Maybe we can share the results of the poll.
Yeah.
Okay,
Yeah.
let's see what we've got. Okay, yeah, so 92% of you have said yes, they were fined. They were all fined for breaching the public health orders, and a couple have said our first 2 options also. So you're right, all 4 people were fined for breaching the New South Wales public health orders. I think most recent of all was Tony Abbott, fined for not wearing a mask, and the infamous snitching. So I thought, Cherie, before we kind of get stuck into what the public health orders are, we might actually ask our participants if they've had clients with public health order fines. And then we can go through maybe some examples of what they are and then some of the data. So We've just launched a poll. Have you had a client with a public health order fine? So options yes, no, and not sure, I haven't asked. Okay, so we'll just give everyone a moment to respond. Okay, we might close that one off and share those results. Okay, so 53% have said no, 31% of you have said that you've had a client with a public health order fine, and 16% have said not sure, I haven't asked. Hopefully after today's session, it's something that you ask all your clients about their fines, and I'm sure Jules and Liz will send that message to all of us. Okay, well, that's a lot. All right, Cherise, so over the last 18 months, there have been a lot of changes about how we live in response to the COVID-19 pandemic. And so how is the New South Wales government making what we now know to be public health orders?
Thanks, Kirsty. Well, the Minister for Health and Medical Research can make orders under Section 7 of the Public Health Act. And as you would have noticed, these orders are amended frequently in response to changing COVID situations in the community and to reflect the current health advice. So due to the changing nature of these orders, it's recommended that you always check for up-to-date information on the government website and the relevant links on the screen. Even though they change frequently, the orders, they are actually legislation. So police are able to issue on-the-spot fines to people who fail to follow these orders and have the discretion to issue warnings.
Okay, so you've touched on what options the police have for dealing with breaches of the public health order, including giving a caution or a warning, issuing a penalty notice or a fine. And it's the case, isn't it, that in some circumstances you can be arrested and given a court attendance notice?
Yes, that's right, Kirsty. The powers are in the Public Health Act, but the orders and the regulations outline the offence, the amount of the fine. And the Public Health Act gives the police a number of options to enforce the public health orders. Because they're an offence, you can be arrested and issued with a CAN. And Anna and Peter from the Human Rights Group will provide further information on arrest powers in the second part of today's session.
Great. So can we maybe have a look at, take us through some of them, and, gathering and movement seems to be one of the biggest.
Yeah, sure. So when we say public health orders, there are several of them. There's a Delta specific one, but there's also a gathering and movement one. Some of the powers are in one order, some are in the other. So it's always helpful to keep up to date with what's relevant. We have rules about how we can move around and gather in a COVID-19 safe way. And so the gathering and movement orders, they can restrict the number of people who can attend different events, ceremonies and venues, the number of people who can visit a home, and whether people can travel or leave their homes.
And so when we're talking about stay at home, are you able to take us through stay at home orders?
Yeah, sure. So the public health orders were recently, in the last few weeks, rewritten to accommodate the future Delta issues that we are facing in the state. So there are 3 levels, and the first one is some regional areas as of Monday were put into the general area we'll talk about later. And the next category of restrictions are stay-at-home orders. So Greater Sydney and some regional areas currently cannot leave their homes without a reasonable excuse. And the main reasons to leave your home that are deemed as reasonable excuses include shopping for food or other essential goods and services. And one person may only leave their home each day for the needs of their personal household, and may take a vulnerable person with them or a minor. For work, if it's not possible to work at home and the business is allowed to remain open, you can leave your home. Medical care or compassionate needs, only one visitor can enter another residence to fulfil carers' responsibilities or provide care or assistance for compassionate reasons. and exercise with no more than one other person, unless members of the same household, in your local government area or up to 5 kilometres from your home. And as of Monday, 13th September, for double vaccinated people, you can have a picnic. You may have seen that in the media with 5 other double vaccinated people, and that includes exercising outdoors. You are able to leave your home for education if it's not possible to do so at home. There are other reasonable excuses. They're in the schedules of the orders, but they're also really neatly outlined on the New South Wales Health website, and that's also linked on the slides.
Great. And what about the areas of concern?
So that's this is the third sort of level that you'll now see as a category in the public health orders, and that's, by the third area I mean they have special further restrictions that apply to people who live in the listed suburbs. So again, you can only leave your home to go to work if you are an authorised worker, and there's a list that's linked in the slides. That you have registered to travel to work outside your LGA, and you have complied with relevant vaccination requirements before you leave the area. And they do differ depending on the type of work that you do. If travelling for work outside Greater Sydney, excluding authorised construction workers, you have to register to travel outside Greater Sydney. And as of the 6th of September, if you are over the age of 16 and live in an LGA of concern, you must not leave your LGA for work unless you comply with COVID-19 vaccination requirements.
I see. And what about the stay-at-home order? What about for the areas of concern, but for those that live and work in the same LGA?
Yeah, this has always been an interesting aspect of the orders. For those who live and work in the LGA and your business is allowed to open, you're able to go to work. You're not required to test, and so you don't need a permit as well. So that's always been an interesting area that can be confusing. Thanks, Kirsty.
No, thanks, Sheree. It is real. I mean, there's nothing but confusion with some of these orders, and I think that's, you know, part of the reason why so many people have been fined. Certainly, you know, a lot of the matters coming across our desk is that, you know, people just simply don't understand the orders, and Jules and Liz will take us through some case studies a bit later. But what about regional New South Wales? And you mentioned earlier that there's been some relaxation of the rules for some parts of New South Wales.
Yeah, so parts of regional New South Wales currently deemed as low risk and which have seen 0 cases for at least 14 days, so that's quite a big step, have emerged from lockdown or stay-at-home orders, but we all call it lockdown, effective Saturday, 11th September, so just last weekend. They will continue to operate under restrictions to ensure the safety of those regional communities. And the following freedoms will be available in where those stay-at-home orders have been lifted. So gatherings in the home and the public space, up to 5 visitors will be allowed in a home, not including children under 12. Up to 20 people can gather outdoors. So just noting that it's not requiring a double vaccination to do those activities in those regional areas which have come out of lockdown. Venues including hospitality, retail stores and gyms, they can reopen subject to 1 person per square metre inside and 1 person per square metre outside, and with standing while drinking outside. Retail stores can open under the 1 person per 4 square metre rule. Personal service such as hairdressers and nail salons can open with 1 person per 4 square metres and capped at 5 clients in the premises. Gyms and indoor recreation facilities can open under the 1 person per 4 square metre rule and can offer classes up to 20 people, and that's indoors. Sporting facilities including swimming pools can reopen. And schools will reopen with level 3 COVID safety measures in place. So that's an exception to the general school dates that have been set by the New South Wales government that I think start on about the 25th of October for the whole state and are, you know, graduated across till November. Shall I keep going, Kirsty? There's
Up to, yeah, I mean, I
yeah,
think there
there's
are some
quite a
also
bit of
some
detail.
changes.
Yeah,
Yeah.
there's quite a bit of detail for stadiums, theatres and major outdoor recreation facilities, but it's really best to go to the New South Wales websites to get the detail on any particular action. But weddings, funerals and other places of worship, they can now have 50 guests to attend a wedding with dancing permitted, eating and drinking. Up to 50 guests can attend funerals with eating and drinking while seated, and churches and places of worship to open subject to 1 person per 4 square metre rule with no singing. And travel, you can travel to caravan parks and camping grounds. They're open now and carpooling's permitted. Now, masks are still mandatory for all indoor public venues, including public transport, hospitality, retail and business premises, planes, airports. Only hospitality staff are required to wear a mask when you're outdoors, and children aged 12 and under will not need to wear a mask. And I think this kind of gives us a glimpse of what's to come as areas move up and down the sort of no stay at home, and areas of concern in the coming months. Thanks, Kirsty.
Yeah. Thanks, Sheree. So, I mean, I think the future is looking a lot brighter than what it is at the moment for people living in Greater Sydney and some of those other areas.
That's right. I'm pretty keen for a swimming pool myself.
Yeah, and a bit of dancing.
Yes, and a haircut.
Yeah,
the list goes on.
Yeah. Sheree, so I thought it might be helpful just to show an example of a public health order fine and look at how many have been issued recently. So we actually got some Revenue New South Wales data which shows that between the 1st of March 2019 and the 6th of September this year, there have been 31,858 public health order fines issued in New South Wales. So that total fines debt is valued at around $28.6 million. So of that 28.6, 3.5 million has been paid, and the majority of these penalty notices have been issued between June and September of this year, and that number is 28,726. And Peter and Anna will talk about the impacts of Operation Stay at Home a little later in today's session. As of the 23rd of August this year, there had been 117 people who challenged their fines in court. We don't have outcomes for those, but figures from Boxer predating the Operation Stay at Home show that in March 2021, the courts had upheld 45 out of the 56 COVID-19 fines that had been challenged. And Jules and Liz will take us through all the options for resolving public health order fines in the third part of today's session. So, Sheree, as we said earlier, the public health orders give the police the discretion to, or the power rather, to issue fines. Are you able to give us some examples of some of the COVID-19 penalties? And you know, that number, that 28 million, is huge. So, yeah, just maybe taking us through some examples.
Yeah, sure. Yeah, sure. And you might find that fines earlier in the current Delta outbreak were a lot less, and then they were increased during the previous months. So that's good to check where it was at if you are noticing a fine. At the moment, $500 for not following orders about mandatory wearing of a face mask. And noting that you have to carry a mask with you at all times, especially in the stay-at-home areas and areas of concern. $5,000 for lying on a permit, and $5,000 for breaching, spitting and coughing order, which is a separate order. $1,000 for not following the other orders, leaving your place of residence in Greater Sydney without a reasonable excuse to do so, or exercising out of your local government area or beyond the 5 kilometre from your place of residence in Greater Sydney. It's $5,500 for each day that you continue to not follow the orders. If the police issued you with a $1,000 fine on Monday for leaving your place of residence without a reasonable excuse, and you do it, and then they find you doing the same thing like again the next day, today, they could issue you a subsequent fine of $5,500 and continue to do so for each day that you continue to not follow the orders.
Wow.
Thanks. Yeah, I mean, they're heavy fines. Some other examples of fines include $5,000 for failure to comply with the obligation to answer questions asked by a contact tracer. And these are specific provisions within the public health order. You'll find these requirements, and $5,000 for failure to comply with obligations to self-isolate if you are diagnosed with COVID-19, and $5,000 for failure to comply with obligations to self-isolate if you are close contact of a person diagnosed with COVID-19. And in addition, these police issued fines, a court can sentence people to 6 months imprisonment and $11,000 fines. And that power comes from the Public Health Act.
Wow, and so we spoke about public health order, the fines requiring people to wear face masks in certain circumstances, and I believe the original penalty amount or the earlier penalty amount was around $200. Now that's been up to $500 dollars for each instance. So those rules require people to wear a face mask in certain settings and in situations, including on public transport, in indoor non-residential premises in New South Wales, like workplaces, shopping centres, and banks. And in addition, requirements in Greater Sydney to carry a face mask at all times, including when you leave your home. But what are some of the other important aspects of face masks that people listening to the webinar should know about?
Yeah, sure, Kirsty. Masks are not required in your own home and when you're visiting someone in their home, except where you live with someone who is self-isolating. So it gets tricky. Exemptions include people aged 12 and under, and those with physical or mental health issues that make wearing a mask unsuitable. And this was an updated order at some stage in the last few months where you must carry evidence, like, for example, a doctor's letter for any of those kind of exemptions, such as physical or mental health issues that prevent you from wearing a mask.
Yeah, and it's really interesting too, because Peter and Anna will talk about this a little bit later, but even just the requirement that you be able to produce evidence when you're approached by a police officer around not wearing a mask, and yeah, it can get very complicated. But I think Peter and Anna are going to make that really clear for us and for everyone participating in the webinar about what you're required to do and answer questions when you're approached by the police. And what about checking in and out?
Yeah, so you also are required to provide your details before you enter certain premises for the purposes of contact tracing. So that's the QR code. This will become even more relevant as we move into a space where double vaccinated people will have different privileges. So unlike some other states in Australia, there are protections in New South Wales legislation which prevents other agencies, including the police, from using QR code data for investigative purposes. So basically, the purpose that the QR code is kept for is for contact tracing and contact tracing alone. But it'll be interesting in the coming months what's done with the QR codes and vaccination status. Thanks, Kirsty.
Yeah, absolutely. Thanks, Sheree. Yeah. And what about the requirements around proof of address?
Yeah, you must carry proof of your address if you are subject to a stay-at-home order, and if you have left your home for a reasonable excuse, or you're exercising outdoors or supervising a child aged 12 or under who is also exercising or playing or engaged in outdoor recreation. And you have to carry proof of your address if you have a reasonable excuse and are leaving the local government areas of concern that have been listed in the slides earlier. And you must show your proof of address if asked by the police. And it's for 16 and over if you are travelling in a passenger vehicle and you have to, it's about the carpooling orders, and so you have to show proof of address so that you can show that you all live in the same place. Thanks, Kirsty.
Thank you, Sheree. And so this has come up quite a bit for our team, and the Public Health Act also allows the making of an order for someone to self-isolate, and that order requires you to remain in your home or the place that you're staying. Can you tell us when the orders will apply?
Yeah, so a self-isolation order will apply if you've had COVID-19 or a close contact of someone with COVID-19. So if you have come into contact with someone who has it as well. If you are identified by a contact tracer as a close contact, if you are a return traveller exempt from hotel quarantine, and if you are waiting for results of a COVID-19 test. You can leave your home for a medical care or an emergency, but you can't go and get a loaf of bread, for example, which some people have been caught throughout the pandemic doing. No one else can enter the premises unless they normally live there or are providing emergency or medical care. And Peter and Anna will talk us through further details on how New South Wales Health or the police can enforce these orders later in the session.
Great. And Shri, in our team in particular, we've seen an increasing number of clients who are subject to orders made under Section 62 of the Public Health Act. Can you take us through what the order is and in what circumstances a Section 62 order can be made?
Yeah, I was pretty interested to hear this, Kirsty. Obviously, health authorities are now using Section 62 of the Public Health Act, which allows the making of an order that a person be detained for the duration of an order and undergo testing as directed. And I think an order, just the next slide there, Kirsty, an order can be made when an authorised medical practitioner is satisfied on reasonable grounds that a person has been exposed to COVID-19 and is at risk of developing COVID-19, and because of the way the person behaves may be a risk to public health.
So when might someone be a risk to public health?
It's pretty extraordinary. An example might be where the authorised medical practitioner is satisfied that a person may not comply with an order or with a clinician's advice or directions while in the community. And my apologies, my daughter was told not to come into the room today while we were presenting, but of course, working from home and the joys.
That's right, we're all there. Yeah, we're all there. Mine arrived downstairs with an unimaginable amount of sweets. So
it's very hard to bribe a 15-year-old. She's very embarrassed now. Thanks, Kirsty.
Oh, no. So just on that Section 62 order, so I mean, we've had some success in our team writing to the authorised officer who's named in the order as being the person responsible for making that order, and you know, we've advocated for the revocation or variation of an order, but outside of that, are there other options to review a decision by New South Wales Health under Section 62?
Yeah, so just moving on to the next slide here. If you're unsuccessful in your representations to New South Wales Health, a person may apply to the New South Wales Civil and Administrative Tribunal to review an order under Section 62. So NCAT may confirm the public health order, or it may vary the order and confirm it as varied, or it may revoke it. And just curiously, Kirsty, was that a lengthy process, or were you able to succeed in the representations with health and you haven't needed to go to NCAT?
Yeah, so in the most recent matter, we didn't need to go to NCAT. This was a matter that Jules had, and she had quite a lot of assistance from our human rights team, the civil law in-house counsel, and Patty from our children's civil law service. But yeah, the written reps were successful, and that particular client was released.
Yeah, great. I mean, you would hope that NCAT would treat the matter as expedited or, you know, speeded up, but it didn't seem the easiest process to me. Thanks.
No, certainly not. So we weren't intending on covering this topic about mandatory vaccinations, but we had an overwhelming number of participants ask this question when they registered for the session. So the question is, can an employer require you to get vaccinated?
Thanks, Kirsty. Interestingly, and this brings back to my role within the organisation. We've been wrestling with this very question, so it is very topical at the moment, and it's all through the media everywhere. As an employee, you have to follow the lawful and reasonable directions of your employer. In many cases, it will be reasonable for your employer to require you to get a COVID-19 vaccination to go to work. For example, it would be reasonable if your employer required you to get a vaccine if a specific law, such as a public health order, requires you to be vaccinated. So then it's lawful. If your work involves interacting with people with increased risk of getting COVID, such as workers in hotel quarantine, airlines, and border control, then that becomes a reasonable direction because it's about risk and safety of the employee.
Are you able to provide some other examples of when it may be reasonable for an employer to require you to get a vaccination?
Yeah, and just a note that if it is reasonable, there's a risk assessment that is in the background to all of that. So there's quite a bit of legal requirements under Work Health Safety Act to make this happen. So this could include, so a reasonable direction could include where your work involves interacting with people who are vulnerable to COVID-19, such as working in aged care. And we've seen that happen. Your work involves interacting with a lot of customers, such as retail workers, or in situations where infection with COVID-19 at work could lead to a super spreader event, such as childcare or schools. If you work in close proximity to lots of other employees, then there is a risk of COVID-19 spreading in the workplace. And if you are working in a place with high rates of community transmission of COVID-19.
Okay, and in what circumstances may it not be reasonable for an employer to direct you to get a coronavirus vaccine?
So it may not be reasonable, and therefore it becomes unlawful if your employer directs you to get a COVID vaccine when you're able to work from home and your work involves limited interaction with the public or other employees. So it may not be reasonable for your employer to require you to get vaccinated against coronavirus if there is a risk to your health, such as if you have allergic reactions to vaccines. And if you are in this situation, you should speak to your doctor to get legal advice. And interestingly, the orders are now speaking about having evidence of contraindication, which is the term that's used in the orders, meaning that you're allergic to vaccines and you're not able to get them for medical reasons. So there are certificates that can be issued.
Yeah, so I think the key message is that really, if there is a question about whether or not a person thinks it's unreasonable for them to get a COVID, for their employer to require them to have a COVID vaccine for work, then they need to get medical advice and legal advice.
That's right. It's a really tricky area, and I think that will be the most difficult topic in the coming weeks and months for employees and employers.
Yeah. And so just to wrap up our section, I thought it might be nice to, ours has been a bit gloomy. It might be nice for us to wrap up with some good news. And so New South Wales Ambulance have exemptions for ambulance fees that are available to people who receive treatment or transport if that treatment or transport relates to COVID-19. And that also includes those people that have had an adverse reaction to a COVID-19 vaccination. So that exemption can be lodged online or you can contact New South Wales Ambulance and the details are on the slide and on the handout. But thank you so much for your time, Cherie.
Oh, it's a pleasure. I've lived and breathed public health orders for the last few months, so it's just nice to be able to share some of it. Thanks for inviting me along today, Kirsty.
No, thank you very much. And so I can see Kerry's popped in. Before we lose Cherie, did you have a question for her?
I know time's a bit of an issue, but just wanted to say that one of our colleagues has posted up that the fines in regards to masks are a bit less for young people. So there's some different fines for aged 18 years or older, as Cherie mentioned, but it's $80 for for 16 to 17-year-olds and $40 for failure age 15 years or younger. So there are some different fines for younger people. I also wanted to just let people know there's a copy of the presentation as a handout on your control panel. Someone asked about that. And then we had a question, there's a couple of questions about how do you have proof if you don't have ID, and what about homeless people in terms of these fines? Can you answer those questions, Cherie?
I can answer the homeless aspect in that homeless people are exempt from some of the requirements in the orders. So depending on the specific question, I'm happy to answer it offline if you want to send through those specific questions. It depends on what the circumstance is, but there is an exemption for homelessness in those cases. And I think some of those other questions might be answered later in the talk. So I might leave them to now, and then we can take them on notice and get back to people, because I think they'll be answered. And thanks for pointing out the lesser fines for junior. I was going to mention that, but I think it is also covered later in the talk. Thanks.
Okay, all right. Well, yes, and other questions we'll be able to answer in the webinar.
Yeah,
Thanks.
Brilliant. Well, thanks, Cherie. And what we'll do now is I will thank you so much for coming. And
thanks, Kirsty. See you.
See you soon. So the next part of today's session is on police powers. So I will introduce to you Anna Dawson. Anna is a senior solicitor in the Human Rights Group, and Anna came to us a couple of years ago now, I think, from PIAC. Are you there, Anna? Oh, there you are. Good morning.
Good morning. Can you hear me?
Yep, perfectly.
Excellent.
And we also have with us Peter Pham, also from the Human Rights Group. Morning, Peter.
Hi, good morning.
Okay, great. Well, I'm going to hand over to both of you, and just let me know when you want me to flick to the next slide.
Great. Thanks, Kirsty. I'm going to start us off today. And I'd like to acknowledge that I'm presenting to you on the unceded land of the Gadigal and Wangal people of the Aurora Nation. I pay my respects to their elders past and present, and to the Aboriginal and Torres Strait Islander people joining us today. As Kirsty mentioned, this part of the presentation focuses on the additional powers that police have been given to enforce the public health orders that are currently in place. As I'm sure most of you know, in addition to these new police powers, since the 16th of August, the New South Wales Police have been implementing Operation Stay at Home, which is purportedly to boost public health order enforcement across the state. The announcement of this operation was also accompanied by reports that the New South Wales Commissioner of Police had directed members to put aside community policing during its blitz on lockdown breaches, and issuing a challenge to members of the course over the course of Operation Stay at Home to go high level enforcement. We know that this announcement and the increased policing and enforcement activity that has since occurred and is still occurring has understandably caused many in the community to feel worry and alarm, particularly those living under increased restrictions in the LGAs of concern, and those in communities already subject to over-policing, such as Aboriginal and Torres Strait Islander people and their communities. So in this session, we aim to clarify exactly when you need to respond to police under the public health orders. Before we begin, just a very quick word about what we mean when we talk about police powers under the public health orders. In day-to-day policing, police officers may approach us and ask questions which we may or may not respond to. Sometimes they have powers, other times it's by cooperation. If we are compelled to respond to police by law in certain circumstances, that is, if it's an offence for us not to respond, or police can take enforcement action if we don't respond, then we refer to it as a police power. So in this way, this part of the session explains when you are required to answer police questions, when you're required to give information or follow requests from police under the public health orders, or else risk breaching the public health orders and facing a penalty. And Cherie and Kirsty spoke about what some of those penalties were earlier. It's an offence. Fines can be applied, and people can also be subject to arrest. So Peter and I are going to cover the following questions. And if you could change the slide there, Kirsty, which just gives an outline. Yeah, so we're going to cover what information can police ask me to provide, what can police ask me to do. We're going to look at a specific situation, which is around if people are required to self-isolate at a home and police knock at a door, what information needs to be provided to them. We'll then look at what other evidence do we need to show to police if requested. And we'll then move on to general tips for dealing with police and interacting with them, and options for getting advice and other assistance. So moving on to the first question around what information do you have to provide? So that's just moving on to the next slide. Thanks, Kirsty. Thank you. So Cherie and Kirsty touched on this already, and we thought it was just worth emphasising again because it applies in lots of circumstances. So the general answer is around name and address information. There are two ways in which police can ask you for this information under the Act and also under the orders. Under the orders, police can ask you to produce evidence of your name and address in a number of situations, including when you're exercising, shopping, or supervising a child who's outdoors playing. And the requirement to provide evidence of name and address appears most relevant to the enforcement of the requirement for people to be staying within certain distances from their home, for example. The requirement to comply with a request for evidence of your name and address also applies to requests that might occur in the course of a lawful vehicle stop by police. So drivers and passengers over the age of 16 in a car can be requested to provide evidence of their name and address. The second way that we've got there that police can seek this kind of information is under the Public Health Act itself. A police officer who suspects a person has contravened one of the orders can direct a person to simply state their full name and address information. And the penalty for failing to comply without a reasonable excuse is a maximum of $5,500. So then another kind of broad question around what police can ask me to do under a public health under the public health orders. And the general answer here is around a request to return home in certain circumstances. So those are, if a police officer has a reasonable suspicion that you're outside of your home without a reasonable excuse, they can request that you return home as soon as reasonably practicable. And remember that what we're saying here, this isn't just, I suppose we're mentioning this because this is something that if you don't comply with, you can face enforcement action. So an obvious example here might be if police received a noise complaint in relation to a home, and on attendance through investigations obtained evidence that a number of people were holding a gathering or a party, and people in attendance were away from their usual place of residence. That's probably enough to ground a reasonable suspicion that people are outside of their home without a reasonable excuse. And police could request that they return to their place of residence in those circumstances. And it's likely also that they'd be at risk of being issued a fine for breach of the order. The final question that I'll address before handing over to Peter is a specific situation in terms of police attending your home. So that question is, if people at my home are required to self-isolate and police knock at my door, what information do I have to provide? So as I said, this only applies in specific circumstances, and the first thing that has to be in place is that you've got to be deemed to be living at what's known as a COVID risk premises. That term has a particular meaning under the orders and means a home where a person or people are required to self-isolate because they've either been diagnosed with COVID or an authorised contact tracer has identified them as likely to have come into contact with a person with COVID and be at risk of developing COVID. So if a person falls into one of these categories and is living at your home, or it's you, then you are living in a COVID risk premises as defined by the orders. So under the public health orders, if you're living in a COVID risk premises and police knock at your door, the orders require you to open the door and comply with a request by police for information about who is present or living there, including providing, again, their names and addresses. Outside this specific circumstance, there's no requirement under the public health order or the general law for a person to respond to a knock at the door by police or to answer their questions. We also note, just as an aside, that under the general law, police only have the power to enter your home without your permission in very specific circumstances, such as with a warrant, for the purpose of making an arrest, or to prevent a breach of the peace. Police do not have power to enter into your home to check or ensure compliance with the orders. They could only do so with your permission. And only authorised officers such as staff from New South Wales Health can enter premises and seize or inspect or copy documents in the premises, but only in very specific circumstances. Before I hand over to Peter, I'll just take the opportunity to address a question that was posed by one of the participants today for the webinar, because it relates to another circumstance where police might knock on your door in relation to the public health orders. So if you go to the next slide there, Kirsty, I think it should be there. So the question that was posed is, if a member of the public makes a complaint about a breach of the public health order and police turn up at my house to investigate, what do I need to do, or what proof do I need to show them? So the general answer to this question is the same answer that we'd give in response to a question about what to do if police turn up to your house to investigate any offence. That answer is that there's no obligation for you to open the door or respond to any questions by police if they're investigating an offence. It's up to you as to whether you choose to cooperate or you choose to answer their questions. The other point to be aware of just generally in terms of police powers to enter onto your land, to come up to your door, when they've done that and they approach the front door to ask the people inside about a suspected criminal offence, they're most likely entering pursuant to what's known as an implied licence or implied consent to enter onto your private land. And that can be revoked by the occupier at any time by a request to leave. That brings me to the end of my section. So I'll now hand over to Peter. He's going to go, he'll start with going into a little bit more detail about all the different types of evidence that you can be requested to produce by police.
Thanks, Anna. Okay, so as we all know, and as has been talked about already, we're all living under a pretty complex matrix of public health orders at the moment. They're getting more and more complex over time. And relatively recently, we've had the strange situation where police are seemingly being given some extra powers to ask you to produce documents. And if you don't produce those documents, you're committing an offence. So this table that's on the screen now has sort of combines all the public health orders as they currently stand, and of course they may change again soon, to show all of the situations when various documents are producible to police at their request. So in these situations, if you're asked to produce one of these things on the left, you have to produce them, otherwise you're committing an offence under the public health orders or under the Public Health Act. So I won't go through all of them in detail because Cherie already talked about much of this, but the most common document that needs to be produced is evidence of name and address, and you can see that you need to be able to produce this in pretty much any circumstance where you leave the house. the question that was asked, what if someone doesn't have ID, is a good example of one of the many gaps in the public health orders where people who are vulnerable aren't necessarily accounted for. The other documents that need to be produced are things like a letter from a doctor or stat dec, as Cherie also mentioned, if you're not wearing a face mask because due to a physical or mental condition, it would be unsuitable. And there's permits and negative test results, which you can be asked to produce if, for example, you're leaving Greater Sydney or leaving an area of concern for work. And this PowerPoint presentation, as Kirsty mentioned, you can follow along with, and you'll have access to this later as well. So don't worry about trying to write all of this down. Evidence of vaccination is a hot topic at the moment, or alternatively, evidence of a medical contraindication, which, as Kirsty said, is a doctor's letter, or it's a specified form which shows that you can't receive a vaccination for a medical reason. And police can ask you to show these forms of evidence if you're leaving an area of concern for work in various industries where public health orders have been passed, making them mandatory for people who work in those industries. And as of Monday, for 5 people who are outside having a picnic, which in 2021 is called a outdoor public gathering, police can ask those 5 people to show evidence of vaccination, and you would have to show it in that circumstance. So we'll just go to the next slide. Thanks, Kirsty. What if you don't show evidence of these things? Well, you can be fined or arrested. If you give police false or misleading information, it's a pretty serious offence. There's a maximum penalty of $11,000 or imprisonment for 6 months. There was a good point made about the fines for children. You can see in this table here that the fines do range from relatively low amounts of $40 or $80, although for children it's not necessarily that low, all the way up to $5,000. And these more serious fines are for the failure to comply with the obligation to answer questions by a contact tracer, or the failure to comply with obligations to self-isolate if you've either been diagnosed with COVID-19 or you've been deemed a close contact of somebody who's been diagnosed with COVID-19. So we'll just go to the next slide, please, Kirsty. The other thing that can happen, as I mentioned, if you don't produce, say, a document that you're lawfully obligated to produce, is that in some circumstances you could be arrested. And in general, for breaching a public health order, police can arrest and charge somebody with that offence, breaching a public health order. Depending on the circumstances, police can either take you back to your home or usual place of residence, or if you're a public health detainee, to the place where you're being detained, such as a hotel, for example, or into police custody. What police can do when they arrest you, where they can take you, depends on which power of arrest they're relying on. In New South Wales, there's a general power for police to arrest people without a warrant, only in circumstances where they suspect on reasonable grounds that the person they're purporting to arrest has committed or is committing an offence, and where it's reasonably necessary to arrest that person. So that means that police can only arrest someone if it's reasonably necessary to do certain things, such as to stop the offence, to establish that person's identity, to bring that person before a court, or to protect the safety and welfare of somebody. Police can't just arrest people because they want to or because it's convenient. In fact, the case law around arrest establishes that it's supposed to be a measure of last resort. So if police could have issued a court attendance notice to someone, let's say, they should do that before resorting to arrest. If police do arrest someone, they are lawfully required to tell that person they're under arrest, to tell that person why they're under arrest, to give their name and place of duty. If police don't do this, though, it's not worth getting into an argument about. It may escalate the situation, and often does. The other power of arrest, which is a relatively new power of arrest, which has been brought in response to COVID-19 is a power of arrest that's been brought in under the Public Health Act. And this power of arrest allows police to arrest someone if they suspect on reasonable grounds that that person is breaching a public health order. This is a little bit confusing because this refers to the individual public health orders made under Section 62 of the Public Health Act, not the broad public health orders or directions that are made against or on the entire community. But if police reasonably suspect that an individual who's subject to a public health order themselves is breaching that order, then police can arrest that person, and they can't take them into custody, but they can take them back to their place of residence or the place specified in the public health order where that person has been ordered to reside or isolate. So we'll just go to the next slide, where I'm going to talk about some tips for dealing with police. Dealing with police can be very difficult for people at the best of times, especially people who themselves find that they are targeted by police or have a lot to do with police in their lives. At present, police are involved in almost every aspect of all of our lives, and they have more power than ever to intrude into our lives. There's seemingly now an air of suspicion whereby when people go outside, there's a suggestion that maybe they're doing something wrong and that police may make inquiries with them to check if they are. And as a result of this air of suspicion, there's quite a lot of tension in the air. It's quite a volatile environment for policing and for the community as well. The police's approach to enforcement seems to be enforce now, ask questions later. The Commissioner came out to say, as many of you have probably seen, that they're prioritising enforcement and compliance over community policing. The Commissioner of Police also said that he wouldn't reprimand or think less of police who unlawfully issue fines or unlawfully execute police powers in policing the pandemic. That's obviously an approach that's quite worrying for us and worrying for the community. And in many ways, we're seeing this play out in the community. So we'll just go to the next slide. How do you mitigate police either unlawfully using their powers or unnecessarily escalating a situation? How do you avoid getting into a situation which just becomes messy or becomes a situation where your rights are breached? There's a few general tips which I'll talk about here, as you can see on the screen. The first one is to stay calm. I know it seems obvious, and I also know that it can be very difficult to remain calm if you feel like you're being targeted by a police officer, or if you feel like the police officer is breaching the law in dealing with you. Nonetheless, I find in my work and in what I see that police often approach situations in an emotionally heightened state. And if the person that they're approaching is also in an emotionally heightened state, then that's a recipe for the situation to escalate. When I talk about escalation, what I really mean there, what I'm worried about there, is for some extra charges to be laid on the person who's being dealt with, charges like resist arrest or assault police, which we often see in situations that escalate and which makes the situation messier for the person who's involved. If the person stays calm, it's much less likely that the situation will escalate and much less likely that the police officer will remain in that emotionally heightened state if they are in that state. The second tip is that silence does not necessarily equal consent. Some people think that if you're silent and don't dispute what police are doing, that you're consenting to what police are doing, but that's not true. Sometimes the best thing to do is actually to allow an overzealous police officer to breach their powers and then to make your case for why it was unlawful later. As a bit of a tangent, it's pretty rare that arguing your rights with a police officer actually works. I'm not saying don't calmly assert your rights to the police officer. Of course, you can do that. But if you are calmly asserting your rights to a police officer and it either doesn't seem to be having any impact or is causing the police officer to escalate the situation, it might be better to cooperate in the moment and save the advocacy for later. As another aside, we're all pretty confused by the various public health orders and laws that have been very quickly passed and are constantly changing every couple of days. It's very likely that police are also confused about this. They, like us, may not know what the laws are. They may not know what the public health orders are. They may not understand fully the extent of their own powers. And so sometimes trying to explain this to them can be a little bit redundant. The third tip is to record. If the person who's having the police interaction can't record themselves, then someone who they're with should record the situation. Obviously, when police are being recorded, it implements transparency and accountability into the situation. Police are less likely to escalate a situation or to act unlawfully. Obviously, it's evidence you can then use later if you need to. Police do wear body-worn video cameras, but it's at police's discretion whether or not they turn those cameras on. Often they don't. For a person who's having a police interaction, they should ask the police officer to turn on their body-worn video camera. But one of the other problems with this is that it can be quite difficult to access the body-worn video camera later. So if you have your own footage, that is very helpful. Finally, when it comes to video, another way to get video is through CCTV. So if the police interaction occurs somewhere near a private business or a government building, somewhere else, there could be CCTV cameras around. And if there are, you can usually, under the Australian privacy principles, ask a private business, for example, to preserve that footage and then access it later. Just a tip there that CCTV footage is routinely deleted after either 7 or 14 days usually, so you have to act fast. And if one of your clients, for example, comes to you and asks about a police interaction, you'd want to get them some legal help, and the lawyer can help that person to access that CCTV footage or preserve it, at least ask for it to be preserved sooner rather than later. Finally, if you need an interpreter, or if your client needs an interpreter, they should ask for one. Obviously, if your client is arrested, they should ask for a lawyer. They have that right. Just before I move to the next slide, which will be my final slide, I just want to give a couple of quick examples of some of what we can call ancillary police conduct that we're hearing about in the policing of public health orders. So this is where a police officer may be approaching somebody or questioning somebody about a public health order or fining them, and in that process they also try to execute another police power, which may or may not be lawful for them to do. So one example that we've heard about is the example of searching somebody, whether it's a general search or a strip search. But police can't search somebody just because they want to. There's pretty stringent requirements in the law about when police can search someone. Police have to suspect on reasonable grounds that an individual is either in possession of a stolen item or something that can be used in a crime, or a dangerous item like a weapon, or an illicit substance like a drug. Now, to suspect one of these things on reasonable grounds, the common law says that reasonable suspicion involves something more than a possibility. So the police can't just sort of think that it's possible that someone has a weapon or a drug on them. There needs to be an actual factual basis for the officer to hold this reasonable suspicion. And another thing there that the common law says is that that factual basis needs to primarily be based on the person's conduct, their conduct in the now, which means how are they actually behaving, how are they actually acting, which gives the officer a reasonable suspicion. It can't be based on what that person looks like, or their socioeconomic status, or anything like that. It has to be based on their conduct. Another quick example I'll give is use of force. And I saw that we got a couple of questions about this as well. In short, police are only allowed to use the amount of force necessary to execute a lawful power. So If police aren't executing a lawful power in the first place, then any force used is unnecessary. If police are, let's say, lawfully arresting someone, they can only use the amount of force that's necessary to actually complete the arrest. So if police were, let's say, issuing a fine for a public health order, it would be difficult to imagine force being necessary in that instance. If they were arresting someone for breaching a public health order and that person was not resisting the arrest, again, you would question whether force is lawful in that instance, and indeed whether arrest is lawful if a court attendance notice couldn't be issued instead. So finally, on the next slide, which tells you about what you can do about a potential unlawful police interaction. The first thing is obvious, to get legal advice and do it sooner rather than later. But generally in civil law, so if you're looking to make a complaint or a civil claim against the police, there are two options available. The first is to make a complaint to the Law Enforcement Conduct Commission, or the LEC for short. The LEC is an independent body which was established in 2017, and they have oversight over the police, and they investigate serious misconduct or serious maladministration within the police. When you make a complaint to the LEC, you're not necessarily seeking an individual remedy for the person who's been wronged. It's instead a way of shining a spotlight on issues within the police more generally. So for example, if a particular police officer has a lot of complaints made against him or her through the LEC, then that police officer may meet some kind of punishment within the police. If a local area command has a lot of complaints made about it in relation to the same thing, then it might be possible that they have to undergo training, or there's some kind of regulatory change within the police to try to stem that problem. So it's a longer term form of advocacy where you're trying to raise awareness about issues within the police more generally. If one of your clients or one of you wants to bring an individual claim against the police and try to get damages for it, then that's a civil claim in tort. So that's where you're suing the police for assault or battery or false imprisonment or malicious prosecution. If one of your clients thinks they might have a right to one of these, it's important to talk to a lawyer to check. And at the end of this presentation, I think we're going to mention how you can do that. Okay, I'll just make sure I haven't missed anything. No, I think that's it. So now my colleagues Liz and Jules are going to talk about fines. I'll just say as well, actually, I did forget one thing, which is just that if your client has been criminally charged and they need criminal advice, then of course they should speak to a criminal lawyer, which we'll mention at the end how they can do that as well. But I'll pass on to Jules and Liz to talk about fines.
Thanks, Peter, and hello everyone. Welcome to our webinar. My name's Jules. I work in Legal Aid's WDO service, and I usually work in Sydney Haymarket office. And today I'm streaming live from Gadigal land. I'm also joined today by my lovely colleague Elizabeth Wai, who works as a solicitor with Law Access. And I'm not sure if you guys know, but Law Access recently joined the Legal Aid family. So we're all working together under the Legal Aid hat. And today we're going to walk you through some of the trends that we've seen with our clients on the ground, and also walk through some case studies and options. So with the next slide, today's message and theme is really about acting on your fines, because as we saw with Kirsty's stats that she presented originally, there's about $29 million worth of public health order debt, and we know that 3.5 million have only been paid to date. So we think that there are people probably sitting on their public health order fines and probably have ignored them. So I think today, if you feel a little bit more confident talking about public health order fines to your client, maybe ask the question, hey, do you have a fine? Hopefully after today you can walk them through some of the steps and options available to them, and if not, refer them to a community legal centre or Legal Aid, who are doing some work on the ground to assist clients with public health order fines. And the next slide. So Elizabeth's going to walk us through. sorry, Elizabeth's going to
Jill.
walk us through some of the enforcement costs and what can happen if you do ignore your fine.
That's right. Thanks, Jules. It's important to respond to a fine because if you do nothing, things can get worse. So enforcement costs can be added. That's generally an extra $65 that's added to your fine if you don't pay it by the due date on the penalty reminder notice, or $25 if you're under the age of 18. If you still don't pay the fine at this stage, your driver license can be suspended and you could also have money garnished. That means that you could have money taken out of your wages or your bank account to pay for the fine. Property could also be seized by the sheriff to sell to pay for the fine. So if you need help, you should get help as soon as you can before it gets to this stage.
Next slide, please.
Next slide.
So Liz, I often get asked a lot of questions from my clients. What happens if I get a public health order fine? How long do I have to act? So here we've done a bit of a life or a fine cycle of what it would look like if we ignored our fine. So say, Liz, you go out shopping, you get you forget to wear your mask and you get a fine of $500. So if you ignore your fine, you actually originally have 21 days to manage it. When you get your first penalty notice. And then if you ignore it after the 21 days, you get a second notice. It's called a penalty reminder notice, which gives you an additional 28 days to manage your fine. So that's about a 7-week window where revenue won't take enforcement action against you. So you can get some legal advice, you can go on a payment plan, or you can go on a work and development order, which we'll discuss in a moment. So that's a 7-week window where essentially you've got time to figure out what you want to do. But Liz, if you ignore your fine for that 7 weeks, the scary thing that happens is that revenue can take what's called enforcement action and they can charge you for it. So if you ignore it after the 7 weeks, your fine can go up from $500 to $565 with that additional cost you mentioned with the $65. And then if you ignore it, you continue to ignore it, they can actually take action to suspend your license with RMS and charge you for it as well. So that $40 comes on top of the fine and on top of the $60. So all up, Liz, that $500 fine you got for not wearing a mask could end up being a $605 fine with all the enforcement action. So I guess after today, the message is try to ask your clients as early as you can so we can get them within that 7-week window so they don't have to worry about any enforcement costs. Because if Liz continues ignoring her fine, she'll actually have the additional issue of maybe even having her license suspended and she won't be able to drive until it's managed. So that's the life cycle of a fine, and I think we'll go to the next slide as well.
Thanks,
and Liz
Juliana.
is going to walk us through options.
Sorry, Juliana. I'll be taking us through the options that you have for dealing with the fine. So as you can see, there's several different options for managing the fine. Of course, you can pay the full amount by the due date, or you can arrange to pay the fine in instalments. You can put in an application to pay by instalments online, by phone, or by completing an application form. And if you're on Centrelink benefits, you can arrange for the instalments to be deducted from your payment through Centrepay. You might also be eligible for a work and development order. Eligible people can pay off their fines by doing unpaid work or completing an educational course, or in some cases getting medical treatment. But Juliana will take us through in a little bit more detail later on about WDOs, so I'll leave that there for now and I'll move on to the next option, which is requesting a review. So this involves asking Revenue New South Wales to review the fine. They could choose to withdraw the fine, particularly if it's incorrectly issued, or they can issue a caution, or they may decide that you still have to pay the fine. This is a free process, and if you're not successful, you still have other options. And the next option is that you could elect to take the fine to court. Going to court can be risky because the court has the power to impose higher maximum penalties than the original fine issued. So for breaching public health orders, the maximum penalty that a court could impose is 6 months prison and a fine of $11,000. The court could also give you a criminal record. So anyone who's considering taking a fine to court should really get legal advice before court electing. You can also request a write-off if you're experiencing severe financial hardship and unable to pay your fine debt. You can ask Revenue New South Wales to cancel that fine. They may waive some or part of your fine. We could go to the next slide, please.
So before we kick off on the WDOs, I think we've got a poll to run, don't we, Kerry, about how many people already know about work and development orders. So how familiar are you already with work and development orders? I'm confident talking about them and also referring them talking to my clients about WDOs and referring my clients. And I don't know much about WDOs, or the last option, I know a bit but would like to know more. So feel free to pop in your poll answers. I think because I've got a few community service providers in, we might actually have a fair few people who know about it. Wow, fantastic. So 38% of you already know about WDOs and feel confident about referring your clients to a WDO sponsor. And then 25% of you say you don't know much about WDOs. And 37% of you say, I know a bit, but would like to know more. Awesome, so we'd love talking to you. So essentially, I'm going to give you an overview of what the WDO is. So the WDO scheme is a world first scheme invented in New South Wales in joint partnership with Legal Aid, the Department of Communities and Justice, and Revenue New South Wales. So the scheme understands that the fine system disproportionately impacts on disadvantaged clients. For example, a $500 public health order fine could mean for some of our vulnerable clients a difference between paying their groceries for a week or paying their electricity bill. So to be eligible for a work and development order, you need to fulfill one of the 6 criteria on your screen. You need to be someone who is in acute financial hardship, which also includes someone who's on an income-tested Centrelink benefit, for example, job seeker or the disability support pension. You might also be, or you might be homeless, and that includes someone who's couch surfing. To be eligible for a WDO, you could also be someone who has a serious addiction to drugs or alcohol, or you could be someone with a mental illness such as depression or anxiety. Or you could also be someone who has a disability or be under the age of 18 for a young person. So you need to fulfill one of these 6 criteria, so you don't need to fulfill all of them, just one. And you also need to turn your mind to your capacity to pay your fine and whether it's appropriate for you to do a WDO. And the other thing that's important for you to know, as I already mentioned, is that you can do a public health order fine. You can put a public health order fine on a work and development order. You would just need to find a community provider who's willing to approve your WDO application and help you with that activity. So some of the wonderful stories I've heard from my clients who have gotten public health order fines and have found a sponsor in the community include people who have gone to do online courses to help them upskill during their current unemployment. I've also heard of people doing volunteer service with their local community centre to help prepare meals and deliver meals to people in the communities to help them pay off some of their public health order fines, because as we know, they can be quite hefty. So yeah, it's up to the discretion of the sponsor to approve your WDO application. So if you do want to undertake a WDO for a public health order fine, the client themselves can find the sponsor, or you can sign up as a community provider yourself to be a sponsor for your clients. Importantly, the maximum you can clear under a WDO is $1,000 per month, and all you need to do is just participate in the approved activity. And we'll go on to the next slide to show what those approved activities are. So some of the activities I already mentioned, things like you can do volunteer work, you can do counselling, you can do drug or alcohol treatment, medical or mental health treatment, an educational course, or mentoring if you're under the age of 25. And the maximum you can possibly clear a month under the scheme is $1,000. And how do you actually find someone who's willing to provide this service to your clients? You can hop onto the Revenue New South Wales website where there's a list of publicly available sponsors and their contact details. Or you can also contact the Legal Aid WDO service where I work. We have a list of our regional sponsors, so we can help you find a suitable sponsor for your client. And you can email us at wdo@legalaid.nsw.gov.au. Next slide. So Liz, another question I got asked by a lot of my clients is, okay, so if I want to dispute my fine, how do I actually do this? And the way I answer is you can do this online. As the Human Rights team mentioned, you can get legal advice first to see if there's merit to your dispute or your challenge. But you or your community provider, your support worker, could also do the review online yourselves. So there is an actual portal online on the Revenue website called My Penalty, and you'll just need to provide the date of the offence and the penalty notice number in order to do the online review. And as Liz, you mentioned, it's absolutely free. It doesn't require going to a court. It's just through an internal dispute mechanism. So essentially, once you submit the review, it goes back to the issuing authority and they can make a determination. And they can, like you mentioned, they can get a caution, they can get the penalty to stand, so it means that they're liable, or they can get the penalty withdrawn. We just suggest putting in some supporting evidence to assist your case. So some examples of what we've submitted are things like a receipt showing that my client was at a grocery shop, or as the human rights team were mentioning, if you've got a recording of police or something that will assist the issuing officer to determine that fine, that would be helpful. We'll go to the next slide. And then I get another question as well from my clients, Liz, about what happens if I can't do a WDO and I can't pay by instalments? What's my other option if I get a public health order fine? And the answer is you can request a write-off. This is a particular option available under Section 101 of the Fines Act, which essentially means that Revenue will not be able to recover money from you because you've got medical, financial, personal circumstances that won't allow you to pay the fine. So we've had clients who have come through this particular stream because they've, for example, had some money, but it's saved up for cancer treatment and they won't be able to do a WDO because they're quite vulnerable and won't be able to go out to the community. So in order to do your write-off application, it's an online process, like we've got a screenshot there. And you also need to go to the Revenue website and they will ask you for supporting evidence. For example, your Centrelink income statement, a financial circumstances statement, just to show your assets and your expenses. And they might also ask you for your bank statements as well. It has been helpful for some of our cases to also have support letters from your GP, for example, to show that you have a particular illness, or if you have a support worker or a social worker, they can also write a support letter as something quite persuasive to explain why they approve or they support the write-off. Okay, and the next slide.
So now we'll talk about how legal aid can help. As Juliana mentioned, Law Access is now part of the legal aid family and we can help you in a number of ways. So firstly, the Law Access website provides publicly available information, guides and step-by-step instructions for anybody dealing with a fine. We can also provide phone help. You can receive information, referrals and in some cases legal advice, and our number is up there on the slide. This is also the best contact number if you need any help to do with what Anna and Peter have discussed in relation to police powers and police conduct. For help with fines and WDOs, contact the Legal Aid Work and Development Order Service, and the email is on the screen for that as well. And if we could go to the next slide, please, Kirsty. Thank you. Here we have a screenshot of the Law Access website. So as you can see, this page has some information for dealing with a fine and some links on the right-hand side to further resources. At the top of the screen, we have a search function to allow you to search for information, and you can change that language from English into another language from the drop-down menu to search for results in another language. Our website also has the read speaker function, which will read out the content on the website. And if we go to the next slide as well, this is just another page. This one's on electing to go to court, and this has information about why you may want to elect to go to court, what you should consider before going to court, and how to elect to go to court, what will happen next if you want to dispute your fine in court. And next slide, please, Kirsty. Thank you.
So now we're going to apply some of the knowledge that we've kind of covered throughout today's webinar to some case studies. I'm going to talk to you about my client Dave. So Dave, he lives in Blacktown, he receives a disability support pension and he has a brain injury. He went to a fruit market to buy his groceries and he wore a mask. He purchased a bag of tomatoes from the market and he saw his friend outside the fruit shop. His friend spoke to Dave, but unfortunately he was not wearing a mask. Dave was stopped by police and he was fined $1,000 for not having a reasonable excuse. Dave could not tell police what he was doing outside the fruit shop. So the question, I guess, that you can pop in the chat, any of your answers to, is what COVID rules do you think apply to Dave's circumstances? And what can we do to help Dave? What do you guys think? Is this something that you guys would talk to Dave about reviewing perhaps? Or would you go to court? Would you do a WDO? Would you go on a payment plan? Let us know your options on the chat box.
Nobody's typed anything. Oh, review. Someone's saying review, review, definitely review, review, referring for legal advice, request for
Great.
review, letter from a
Great
doctor
answers.
regarding review, review, review.
Great. Perfect. So this is a perfect review example. The reason being we got instructions from Dave that he was buying groceries. He's actually holding a bag of tomatoes when police stopped him. And we've got a receipt from the grocery shop that shows that he purchased the tomatoes. So he was only fined for not having a reasonable excuse. And as we know, that it is a reasonable excuse to leave your home to buy groceries. So yeah, we did a review for this one. And the most important thing as well, in relation to people who have disabilities, or if you're working with people with disabilities and they're stopped by police, some of the things that we found really helpful to advise and inform caseworkers on is the importance of maybe having a letter describing the person's disability, saying, you know, this is Dave, I'm Dave's caseworker, Dave has an acquired brain injury, he's nonverbal. If you would wish to speak to him about his conduct, please call me on this number. And we've sent it out to a local area command so that they're aware that Dave might be known to police and might be getting these types of fines. So this has been helpful, but as I say, the review is probably your best option here. And that's a good one. And if it's unsuccessful, Dave has the option of going to court as well, and obviously speaking to our lawyers before so. And he could be represented by some of the community legal centres. I know IDRS are helping some of our clients with cognitive impairments. So there's also a referral there as well if he wants to court elect.
Thanks, Juliana. And our next case study is Steve. So Steve was given a fine by police and he wasn't sure why. This is somebody I've spoken to. He had been in the car with his girlfriend who he lived with, and they went to pick up dinner. Steve said he knew that the public health orders allow you to travel in a car together with someone that you live with, and that it was a reasonable excuse to leave the house to get food. Can anyone guess what Steve might have done wrong from that information? Pop your answers in the chat if you think you know why police may have given Steve the fine in this situation. I'll give you a couple of minutes to think, and Kerry, let us know if any answers come in.
People suggesting they both went to get food, only one person's allowed, only one person not wearing a mask, address details, mask, carpooling. Does that sound vaguely right?
Yeah, no, that's great. Thank you, everyone who responded. So in a situation like this, sometimes identifying what the breach is can be difficult, and a person may need some help in working out what it is that police have said they've done wrong. And often the infringement itself won't actually specify what the breach is. It might just say something like you failed to comply with the notice direction. So in a case like Steve, he may need some legal advice, or he may need to do some further investigating, like contacting police to find out more information about why the fine was given. In Steve's case, he was correct about you can be in the car together with members of your household, and it is a reasonable excuse to leave your home to get food. But as many people suggested, the public health orders state that unless it's not reasonably practicable, a person must not leave their place of residence if a member of the person's household, including that person, has already left the place of residence on that day to obtain goods or services. This may be the reason that police issued Steve a fine. And in a case like this, if you still can't work out why you got the fine, by looking at it, you may have to get legal advice or contact police to find some more information, because that will be important in informing what steps Steve might want to do next in terms of disputing the fine, requesting a review or take it to court, or his options for paying it, or if he can't pay it, if he's eligible for a WDO or a write-off.
And a really good tip, Liz, we found working with community workers as well, is that if you sign up as an advocate with Revenue New South Wales, you can actually call the advocates hotline and with the client's consent provide the name, the date of birth and the address, and the advocates team at Revenue can forward you the Part A of the penalty notice. And the Part A is simply just a fancy way of saying the police notes. And I found that some of the reasons that the police have actually fined the client are listed there rather than just the generic failure to comply with direction given. So that's a really good tip for advocates or people who would like to sign up if you're a service provider. But as Liz said, calling the local area command, you can ask them police to identify themselves and where they're from, and you can then call them if you feel that that's appropriate. Okay, last case study, and this is my client Nock. So Nock lives in Bankstown and he's currently receiving the Centrelink COVID disaster payment. He's identified as a close contact and he gets a COVID test. On the way home though, he stops to pick up a free printer because he saw an ad saying that the printer was 8 kilometres away from his house. He needs the printer because he recently enrolled in a TAFE course and he was fined $5,000 by police because he needed to self-isolate. He speaks Vietnamese and doesn't speak English very well. He tells you he just can't pay the fine. $5,000 is a lot for someone unemployed. So what COVID rules do you think apply to Nock, and what can Nock do? Feel free to pop in your answers in the chat.
Okay, so people are saying needs to go straight home after testing, not self-isolating, asking for an interpreter, can't travel more than 5 Ks, just around the self-isolating is, yeah, and the kilometres.
Perfect, Kerry. So yes, we managed to track down how far this printer was, and it was 8 kilometres. So he was well outside his radius, so he did breach those rules. But the one that the cops caught him on was he was identified as a close contact, like you guys said, and he needed to go straight home and not stop midway and do something else. So Nock took responsibility, and what we actually ended up doing with Nock, or suggesting that he do, is that he could either go on a payment plan or a WDO, and he was thrilled to know that TAFE were a WDO sponsor. So he's now doing his online courses through the WDO scheme at TAFE, and he's paying off his $5,000 fine. So that was a good outcome. And I think that's it for today. We've got one last slide, I think, that's helpful for everyone to know. One of the things that we did recommend, even with people like Nock who were stopped by police, is they can call the TIS line 131450 or request police to call an interpreter if they need to, in order to understand why they've been fined. But there are also a number of multilingual resources out there on the stay-at-home orders, and SBS have recently started offering translated or interpreted live streaming of the Premier's press conferences every morning. So I think that's really helpful for your clients if they want to stay up to date with some of the COVID rules and they speak a language other than English. And we're also doing a social media campaign to promote the awareness of public health order rules amongst the community, different community language groups as well. And we'll just have one more slide really quickly, going to wrap up with everyone. Because these rules change, we do recommend that you go straight to the source, which is the New South Wales government website on the COVID rules. And this particular website, we found out you can actually change the language as well for some of your clients who don't speak English very well. So that's a really good resource to give out to your clients as well. And thank you so much for your time and for participating in the chat and all the polls. It's been really a pleasure on behalf of everyone to be here talking to you guys about what is a really pertinent issue. Yeah, thank you.
Thank you, everyone. And if we haven't gotten to your questions because we are over time, then we will reply to you via email. But thank you so much for your participation and for all of our speakers too. And we hope that you got some information from today's session that maybe you didn't have before. So thanks so much for your time and all the best.
Yeah, and I'll just remind everyone, you'll get a survey after we close the webinar to please give us your feedback. And an hour after the webinar, you'll also get an email with links to all the resources that our presenters have covered today. So have a look at that and keep that in your inbox as a resource for dealing with your clients. So yeah, definitely if you want to type questions in now, we'll be following them up after the webinar. We'll close it in a few minutes.